We've spoken about some of the specific risks that have been arising from environmental and technological issues. And these obviously impact on the financial risks for directors and directly impact upon directors and officers' insurance and the availability of that insurance. Over the past 5 years, we've seen the Australian market for D&O insurance as particularly volatile, and there's been an increase in premiums. However, insurers are now predicting a softer D&O market, and even though risks are increasing, the good news for directors is that premiums have been decreasing since mid-last year. The main reason for this seems to be that there are more insurance players in the market, which is obviously driving competition and putting downward pressure on prices. Have you found that directors of companies in riskier industries or startups are finding it more difficult to obtain D&O insurance, notwithstanding this softer market?
Yes, Elizabeth. We're noticing new competition, particularly from London insurers, and more flexible terms being offered, giving companies more options and the ability to negotiate limits and coverage. This is particularly true for the industries most affected by the pandemic, including travel, tourism, and leisure. And those ones are benefiting from significant post-COVID premium decreases. Of course, directors should be proactive and prudent in reviewing any proposed D&O insurance terms, both on behalf of their company and themselves personally. Companies which are finding it difficult to obtain affordable D&O insurance may seek to cut costs by reducing liability limits. However, directors need to consider the risks of such changes in the event of a large claim. For example, some listed companies are opting to reduce or cease company securities side C cover, which could leave directors liable for market conduct breaches. Directors should inform themselves of the particular risk profile of their company and ensure those risks are adequately covered when negotiating with the D&O insurer, particularly given the increase in significant class actions in Australia. Acting on their own behalf, directors should ensure they have a deed of access, indemnity and insurance with their company and carefully review the applicable D&O policy, as well as being actively involved in their company's insurance decisions to ensure they are adequately protected against the personal financial risks arising from their position. At the same time, directors must remain vigilant in complying with their obligations, as recent cases demonstrate that courts are willing to impose penalties on directors personally, regardless of any insurance and indemnification arrangements.
Yes, there's been some interesting movements in the D&O market, and another part of the matrix has been the rise in third-party litigation funding, which has been allowed in Australia, and it's often used in single-party insolvency-related and class action litigation. The introduction of the litigation funding regulations in late 2022 greatly decreased the regulation of litigation funders by exempting them from certain financial services and other requirements under the Corporations Act. And this, amongst other factors, seems to have resulted in a rise of litigation funders. What do you think has been the main impact of this for directors and business generally?
The government's current reform agenda doesn't include reform to litigation funding. But as you point out, there has been a rapid rise in successful class actions recently, and with that, a rise in investment with litigation funders. The market size of this industry is projected to continue growing over the next 5 years boosted by increasing awareness of litigation funding services and rising demand from class action cases. This growth was further propelled by significant federal court judgments late last year approving common fund orders. For directors, this means they are facing more risk of class action proceedings, particularly in the emerging areas we have discussed today. So, ESG, cybersecurity and privacy breaches, as well as actions against AI providers. It's another signal for directors, particularly those on boards and committees of listed companies, to keep abreast of legal developments and their duties in these areas.
You mentioned the exposure for directors to class action proceedings for privacy breaches. And there's also the risk of privacy breaches stemming from cyber attacks, which give rise to their own set of disclosure obligations. It will be interesting to see with the upcoming privacy reforms, which are designed to bring Australian privacy law into the digital age, and they're designed to also create stronger protections for personal data. There's a proposal for a new direct right of action to seek compensation as a result of loss or damage suffered due to a serious breach of privacy, and this could lead to a significant increase in funded class actions in this area. The AICD has noted particularly careful drafting and appropriate constraints will be essential for this proposed right of action under the new privacy laws, including taking account of cyber attacks. What are your thoughts on this, Ben?
With the extent of this new direct right of action remains to be seen. However, the reforms will require directors to be vigilant with respect to the protection of personal data in the realms of AI and cyber attacks. Directors of small businesses in particular ought to be on high alert, as the proposed removal of the small business exemption means they will have a lot of catching up to do to ensure compliance when the new privacy legislation takes effect. While we wait for details of these reforms, directors should consider having their companies run privacy health checks of their compliance frameworks to ensure they are on top of existing obligations, as well as building capacity to comply with new applications in the pipeline.
If we step back a bit, it's an interesting landscape for directors between the corporate governance framework, ensuring that they comply with all these emerging and evolving risks, and still staying focused on the big picture. We've looked at ESG, cyber, AI, and privacy issues, and they sit under the umbrella of the continuous disclosure obligations. But in addition to these diverse and intersecting issues, directors obviously need to consider company strategy as well. It looks like directors are being presented with a pretty elaborate mix of risk and a pretty difficult risk management matrix. Many directors are attracted to board positions because they want to share their expertise and they like to devote their time towards company strategy and navigating the big issues. But they're also under considerable pressure to examine the business from all angles in order to protect themselves and the business from regulatory obligations. How can directors steer away from being caught up in chasing the mice and stay focused on the big picture?
It's a really good question, Elizabeth. You're totally right. All of the regulations are only going in one way, and that's to make the directors' jobs more difficult. I think they're increasingly finding the current level of reporting requirements and regulations too prescriptive, and the heightened risk of personal liability for decisions made by the board only adds to the pressure cooker environment. So it's no surprise that directors feel the need to be on top of all aspects of their business's activities. However, by delving too deeply into day-to-day operational matters, directors can lose sight of their role in strategically directing the business, which can have significant effects on business growth. To ensure the board is focused on vision and strategy rather than on the minutiae of managing the day-to-day, directors should look critically at the company's corporate governance framework and consider making changes to clearly distinguish between the role of the board and management. For example, updating the board charter, reframing meeting agendas, and streamlining board papers and processes, as it is critical to ensure that information flows to the board are clear, concise, and timely.
Absolutely. High quality and succinct board papers, which clearly flag key issues, are definitely the backbone of good governance. And it really is essential that directors are given sufficient time to review the papers before the board meeting, which I suspect perhaps doesn't happen all the time, given my experience in-house over the years. I think it can easily be one of those governance matters that gets missed. The bottom line is that directors need to know their business. And as the chair, Joe Longo, framed this well last year at the AICD Governance Summit. And he said directors must be willing to ask themselves the big three questions. Do I understand the business of which I'm a director? Do I have a continuous curiosity? And do I understand all aspects of the company's core business, as well as the reasonably foreseeable financial and non-financial risks posed by that business? And am I committed to challenging management to ensure that my understanding is well-founded? So it looks like directors have got their work cut out for them. It's exciting times ahead, but I think being able to answer those questions in the current environment will definitely be a challenge. One of the more interesting propositions for directors is a non-executive director role. These positions also come with significant risks, particularly in the current market, as we've been discussing. Whilst non-executive directors have the same legal responsibility as executive directors, there's an important distinction. Whereas executive directors are actively engaged in the day-to-day management of the company, non-executive directors are independent to corporate management, and they're there to provide oversight and expertise, as well as challenging management when required. I'm wondering if you're seeing good candidates for non-executive directors opting out because of the risks of reputational damage, or perhaps the role not being seen as interesting as it once was. Interestingly, on that point, the Corporate Governance Institute noted that 60% of non-executive directors say that the role has become more demanding. What message would you give to those considering becoming a non-executive director?
It's certainly not a role that is to be undertaken lightly. Essentially, we're stepping into a role with the same legal duties and liabilities as an executive director, but because you're not an employee of the company, you have the added responsibility of ensuring that you're given sufficient information about the company's activities to meet your obligations as a director. NEDs need to make sure they understand not only the company's financials, but also the key commercial arrangements and particular risk areas for the business, such as litigation, cybersecurity, or environmental risks. As a result of the increased risk profile of businesses operating in these highly regulated arenas, I would expect to see a drop in the number of candidates willing to take up NED positions on those boards, particularly because we live in a world of intense media scrutiny and online engagement, where the reputational consequences of a director's actions or inaction can be immediate and widespread. This is particularly concerning for those on the boards of listed and high-profile companies, and can have long-term ramifications, both professionally and personally. An effective way to mitigate your risk as a NED is to really understand the role being offered to you and conducting thorough due diligence on the company before accepting the appointment. If you undertake this risk assessment and find a company and a board that aligns with your values, the rewards of becoming a non-executive director could outweigh the risks.
We've considered some really interesting issues for the boardroom in 2024, which are going to require directors to carefully look at their risk profile and also the opportunities for the business this year, and to make sure that their corporate governance frameworks and internal processes are up to the task. It's an exciting time to be a director as we go through a green and technological revolution. And I guess the takeaway message for directors is that boards who prepare early and stay agile will be in the best position to respond quickly and effectively to the inevitable challenges and opportunities which lie ahead. Thank you very much today for joining me, Ben, and sharing your insights.
It's been a pleasure, Elizabeth. Thank you for the opportunity. It certainly looks to be an interesting and busy year for Australian boards, and I would encourage all directors to make good use of their internal and external legal teams as they face the challenges and opportunities ahead. Thanks very much.
Thanks, Ben.